Ciao a tutti. It looks like we're ready to start. Well, maybe. This is Prof. Joe at Prof. Joe Explains, and I hope you had a good evening. It's very early in the morning for me. It's 8:30 here, and 8:30 is not my time of day. Very much not my time of day. So I am sacrificing to be able to do this. I don't know why judges can't start at noon and go till 9 or 10. It seems to me that would be much more civilized, but they run on their own schedule and they don't consult with me. It's really amazing. That's the difference when you teach law. Even unlike other university professors, we really chart our own ships. We are sort of in control. And I can decide, well, I can't decide when I want to have my class. Well, I can because I can pick the time, before the schedule starts for the semester, and seniority means you pick first. But after that, what goes on in the class and everything else is mine. If I want to decide to cancel or not to cancel, I never canceled, but to reschedule a class, I would do it. Of course, when I rescheduled, I always found a time that was also convenient for the students, but it was really in my control. The syllabus is in my control. So being a law professor gave you a lot of autonomy, and I don't know how many other jobs do that. I can't say. I know being a prosecutor wasn't the same. There was still a fair amount of autonomy. It was not like teaching law. In law teaching, you almost have your own little fiefdom. And having your own little fiefdom, even if it's a little fiefdom, is nice, I must say. So, okay, we are going to proceed with the trial today. You may recall that the judge said yesterday that they may be taking a couple of witnesses out of order because of their scheduling issues. And then they're going to come back to the officer who was on the stand at the end of yesterday. So that will be the process by which this goes, and we'll see. I mean, now see, they confused us. They put up, we see a different video or screen from the courtroom, which suggested to us that we were ready to go, but clearly we're not ready to go. And as I recall, the judge, he did say yesterday that they might have something to do this morning before they started. So let me see if overnight you managed to get some questions here. Okay. I don't see any questions. If you've got questions, put question marks, and maybe you could put 6 or 7 rather than 3, because this is early in the day. So the more you do to help me locate, while my eyes do not want to be locating anything at all, the more help, the more likely that I'll be able to find something. So Blue River woke up at 3:30 a.m. See, that's my time of day. At 3:30, I'm usually awake. Not because I got up, but because I haven't yet gone to sleep. Oh, and Jeremiah MCG said he wakes up around 5:03 naturally on the weekdays. Well, waking naturally at 5:30 seems to me to be a real disability. You should be able to get disability payments for that. If I were running Social Security, you would qualify for disability if your body told you had to be awake at 5:30 when you had nothing that you needed to do. That's how I would run the world. Okay, let me see. I don't think there are very many people who are up yet here. Certainly there aren't many who are posting anything that I see. You're just saying hello to everybody. That's very nice that you're telling everybody hello. Good morning from Virginia. That's Annalie Finch. That's still Eastern time. Of course, we're better than anybody who's west of us. Because it's even earlier for them. If anybody's on the East Coast, God, would it be 5:30 where you are? West Coast? That's unbearable. Of course, Jeremiah McG, if you were on the West Coast, you would have gotten up just in time for this, because it would be 5:30. Okay, let's see. What was your evaluation? Jeremiah McG wants to know what my evaluation was of the opening statements. I actually thought, let me see if I can remember now. I thought the state's opening statement was very good. It certainly, I thought for any juror who didn't know any of the facts of the case, it really would have hit very hard when she went through and described what happened. And I thought the defense did a pretty good job. There was something, now I'm going to have to try to recall something about the defense opening that I did not really like very much. But in general, I thought the defense did a good job. I was curious about her giving her example of reasonable doubt. I thought that sort of lopped over into argument, and opening statements are supposed to lay out your roadmap, but you're not supposed to be arguing your case there. But in one of my recaps, I talked to a former judge, actually 2 stints as a judge in New Jersey, banked by, I think it was 7 years as a prosecutor. And she said, well, they're allowed to talk about reasonable doubt. And I think, that sort of would be just a different way to explain reasonable doubt. And I think she probably was right, although it did still sound to me to be a little more than she should be entitled to say. But it was already during opening that I decided I might not really appreciate the style of the defense lawyer, which certainly has borne fruit. But I was already inclined that way because I had seen one motion that she did. I don't know that she'd call it a motion, but an application when they were doing jury voir dire, when she wanted to do them one by one outside the presence of the jury. I think that was the particular request. And she got up there and made her argument, and the judge didn't, I don't even know that he'd said anything, but then she said, I've done this with judges every time, and sometimes it strikes them as unusual, but in every single case, I've been able to persuade them. And then she went on and made the argument again. And I thought the way she phrased it was a little arrogant and a little insulting to the judge. And as we saw during the cross-examinations, she pushed and pushed, and he gave her a lot of leeway. And finally, he said to her, I hear that you have experience as a trial lawyer, and in your experience, this is the right way to do voir dire. I have experience as a in trials also, and I have a different experience in terms of how to do voir dire, and we're doing it my way. And so I'd already been inclined to think she was going to be a big helping of pie to have to sit through. It was going to be very, very, I guess I shouldn't use a sweet example, but you know what I mean. She was going to be tough, and she has certainly demonstrated that. And I think a little of that came out in the opening. But having gone on a long description of all that, I thought she did in the opening what she needed to do in the opening. And I was struck in the opening by her suggesting that maybe it was the third brother, Corey, who had done the arsons and the murders. And, that wasn't anything that she did or said, although she alerted the jury that might be a theory that they would be going on. But I was struck at the willingness of the defendant to try to cast the blame on another brother. But I guess since he's being prosecuted for murdering a brother, the sister-in-law, and then 2 small children, that trying to put the blame on somebody else would be a real lesser included of all of it. So anyway, I thought both of the openings were good. I thought the state's was better. Okay. Other questions in here? No, I don't see any cues. You're just ready to go. And oh, somebody just said buenos dias. So we're getting a Spanish good day. Oh, do people know other languages that we can say good day in while we're waiting? Let me see. We might as well learn some languages as we go. Can anybody say it in Japanese? Good morning. I have a 11-year-old nephew who has decided to learn Japanese on Duolingo. He doesn't have an explanation for why he decided it. And I don't know how long he'll go before he decides it's too difficult to learn on his own. But right now he's learning Japanese. Okay. I don't see anybody saying good morning in Japanese. How about Chinese? Anybody do it in Chinese? Russian? How about Russian? Oh, Godendag is Icelandic. I don't know if I pronounced that right, but Godendag? Okay, thank you. Thank you. Astabjorn daughter. Godendag. I like that. I like the sound of that. That's kind of a happy sound. Godendag. I like that sound. Okay. Goimo. Now I know I'm not pronouncing that right. I'm sorry, Renee Marius, but I'm sure I'm not doing it right. Goye More. If I knew it phonetically, I'd try it. That's Afrikaans. Hebrew. I was going to ask about Hebrew. Bokertov or Bokotov. That's nice too. It's got a nice little staccato to it, which I think is the way to start the day, with just a little bit of energy. Oh, Hungarian. Jonapat. Jonapat, and Hebrew is Bokotov, and Icelandic is Golden Dog. The Golden Dog, they all sound, a little bit alike. Greek, oh my. Kalimerta. Christine Barbas is giving us Greek. Kalimerta. Oh, wow. And here's Latin. Oh, we've got a scholar. Gen X is a scholar. We've got Latin. Bonum diem habeas. Bonum dies habeas. Okay. Oh, God. We've got Arabic. Eric Lieber. Those of you who can see this chat, I can't. I wouldn't even be able to write it, much less pronounce it. I have no idea how you thank you very much, Eric Lieber. That starts us out with a real chuckle. I couldn't possibly pronounce it, and I'm sorry that I can't do it, but I clearly can't do it. And then Denise Collette said Konnichiwa, but no language with it, so we don't know what the language was. And here we're back to Guten Tag, German. Okay. Oh, Portuguese. Bom dia. That's close to Buenos dias, isn't it? Yeah, it is. Bom dia. In Italian, good day is really buongiorno. Hi, Jen. Now, I thought that was another language, but it's not. Eric Lieber, Saba El Kahir. Did I get close to it this time, Eric Lieber? Now that you've given us the sort of the letters that we can recognize, and then we can try the language. Sabah El Kahir. I like that too. They all sound pretty staccato, which I like. You could hear my music at the start has a staccato cadence to it. Okay. Oh, Japanese. I should have known that because I mentioned Japanese. Konnichiwa. I might have gotten the letters pronounced right, but I know I don't have the inflection right. It's too bad we can't hear these. We just can read them. Eric Cleaver said I was close enough. That was very kind. But I don't mind direct criticism that says, you were a mile away. Try again. I think we should do more of that in teaching. I think we should all be adult enough and interested in learning enough to handle direct criticism. I know that's not true of a lot of people. Oh, now we're getting a phonetic. Konnichiwa. But I still don't think I'm getting the inflection quite right. Konnichiwa. Okay. That's pretty too. I like all of those. This chat disappears. Otherwise, I would try to group them all in a list. I think it would be fun to see them all. But the chat disappears, and by the end of the day, I won't be able to see them and do them. Oh, the judge is on the bench. Konnichiwa. Oh, I think that's how to do it. Konnichiwa. I think that might be right. It sounds Japanese to me. Okay, konnichiwa. I should write that down and impress my 11-year-old nephew. Not much impresses him. Certainly not much I do impresses him. He just looks at me with this look, which says, I don't know whether you just don't have a brain, or you just think you're being funny and you're not, or what you're doing, but whatever you're doing, it does not resonate. Perfect. Thank you, Belvi. Uh, Konnichiwa. Huh. Well, I knew I had it when I listened to it because it sounded right. Not that I've heard a lot of Japanese in my life, but I've heard some. When I took Italian in Florence, there was a Japanese woman in my class, and she moved to sit next to me and told me it was because English and Japanese were alike, and we needed to band together against the students from the Romance language countries who have reflexive verbs and all kinds of things that we don't have in English. And she said they don't have in Japanese. So we did bind because we were the two who had a lot of trouble with those those tenses and those and the reflexive verbs in particular, but not just the reflexive verbs. And I still have trouble, but we had a good time sitting next to each other doing it. Okay, Beth Wood. What do I think about the judge always inserting himself in the case when he asks questions he thinks the lawyer should be asking? Does it interrupt the judge's flow? I have mixed feelings about it. He's trying to assure that the jurors are going to be able to follow the what the lawyers are trying to do and the points they're making, and the lawyer should be doing it. But on the other hand, he is interjecting, and he doesn't seem to be doing it as much with the prosecutor. And I said yesterday that plus his exasperation with the defense lawyer, calling her up to the bench as many times as he did, is conveying a sense to the jurors that he doesn't like her, and they follow the judge's lead. And I think it's going to end up being an appealable issue. But to the extent what he's doing is clarifying the record and making sure both sides identify the document or the photograph they're looking at or the clip from the video that they're looking at, I applaud him. The lawyers should be doing it. The prosecutor is not doing a bad job. The defense lawyer keeps forgetting. And you've got to have that clear, because reading a cold transcript, you cannot tell what they're talking about. And if there's an appeal based on a photograph or an appeal based on a particular document, and in the appellate record, you can't figure out which one they're talking about, or it takes you a long time to figure it out, it's terrible. So there, I applaud the judge, and I don't think that would be any kind of an appealable issue. I think to the extent he's clarifying for the jury, it's helpful, although now we're moving a little towards maybe issues later. But then when he interjects questions, particularly the first day, I think it was, when he would interject a comment and then sustain his own objection, now I think he's really creating a record for the defense to use on appeal. So I think he should be careful about it. He certainly needs to be careful about his tone of voice and his facial expressions. And there was one time yesterday when he came close to shouting at her. I thought he was right, but nonetheless, it has an impact on the jury. He has an impact on the jury. They really like him. He jokes with them. They feel free to talk to him from their seats. And so he's got a good relationship with the jury, and he should be, I know he's cognizant of the influence he might have and that he needs to be careful about it. But I think a couple of times she just got so far under his skin that he went a little too far. Okay, let's see. Okay, now Blue River has decided to write in a different alphabet, so I won't be able to read it. Thinking that showing once that I couldn't read it wasn't enough, we should do it again. That doesn't look like the Arabic that I saw in the other message. Is that Arabic also, or is that another language? Okay, Elizabeth Shutter said she hasn't been able to watch this week. Can I do a quick recap of who has testified so far? You're asking me to do this at, now what time is it? 8:45 in the morning, so that's quite a lift. But two of the neighbors who lived next door to Paul Caneiro testified. about what they saw the morning of the fire, starting at 4:30 in the morning. One, maybe two neighbors, I'm trying to remember, testified about the fire at Keith Caneiro's house. It was the neighbor from across the street, and maybe there were two of them, but they testified about what they saw there at the when the fire was noticed at Keith's house, which was about, I think the first report came in a little after noon, maybe 12:30, whereas at Paul's house it was at 4:30. So there was about what would that be, an 8-hour time difference. There were several law enforcement officers who testified from different county law enforcement units. There were a number of different counties on the scene, I think 3 maybe, at least on one of the scenes. There were also people who arrived from the prosecutor's office, their forensics unit, I believe, and there were firefighters there from more than one county. There was an investigative fire chief, I believe it was his title, who testified about what his job was on the scene, and his job was to make a quick perimeter to get a sense of what was going on. I forget what he called it. There were 2 terms for it. And then he had to note anything he thought would warrant for further investigation and what type investigation. And he also had to decide whether the follow-up was within the resources and expertise of his unit or whether they had to switch it over. And I think they were switching it over to Monmouth County, which is a larger county than where he worked. So the firefighters testified. I'm trying to think if anybody besides law enforcement and the neighbors testified the first couple of days. There was a forensic accountant from the police department who testified. There was also the Caneiro brothers accountant who testified about some of the financial documents that they had and the extent to which, he didn't say, but what the prosecution was getting at was the extent to which they demonstrated that Paul Caneiro was either not paying insurance premiums he was supposed to be paying, or was moving money from the business accounts into his personal account. The police detective, the forensic accountant for the police, also testified to what the documents showed in terms of Paul Caneiro's monkeying with the company money and maybe family money there too. There was also the insurance agent for the Caneiro brothers. His title wasn't agent, but I don't remember what it was, who testified. Again, with regard to the insurance policies. So I think, unless somebody in the chat remembers someone else who testified, I think that was the list of everyone who testified. And you will see that Paul Caneiro has been wearing sweaters, not a jacket and tie every day. And we've had a discussion in the chat about why the defense lawyers think that's a better look for him. And we've had a couple of guesses. One being that in the Diddy trial, he wore sweaters every day and it worked for him. So maybe that's what Paul was doing. Another suggesting that maybe the push was to make him look mild-mannered and not aggressive in those soft sweaters, and that's why the defense has him in the sweaters. So we did that too. What you missed, a big thing that you missed in the last few days, which I alluded to somewhere this morning already, is that the defense lawyer has been quite the person to watch. She's got, I don't know if I'd call it an abrasive style. She certainly has a pushy style. And I've watched some of these trials with people in the chat now, and we've hit lawyers where a lot of people in the chat think they're arrogant or abrasive or pushy, and they don't like them. And none of them I've reacted to that way. They just seem to be like a lot of people I know. But this particular defense lawyer is one that I'm reacting to, because she's got a level of arrogance and a patronizing tone. I'm now going to explain it to you because you simply don't understand it, Judge. And then she doesn't give up. He can rule, and she'll keep pushing, and then she'll do it again, and he will tell her again that he sustained an objection at one point yesterday. I think it must have been the fourth trial. It was at least the third trial to go back and do what he told her she could not do. It was hearsay. And he finally, in his tone, made it clear that he wasn't unhappy, and he called her up to the bench. And he's called them up to the bench, my guess is at least 4 or 5 times. That one stood out because his tone really suggested he'd had it. And he's been trying, the other thing that's occurred over and over again is he's been trying to get the prosecutor to make more objections with regard to hearsay, with regard to her questions being outside the scope of direct examination, with regard to the fact that she's being repetitive. Those are the 3 things that she's doing. And he has not been successful in getting the prosecutor to do it. And that's been exasperating to him. And that's why he's been interjecting and saying that's repetitive, or you're testifying that the witness didn't say that. And that's the stuff that the prosecutor should be doing. That's what led to the earlier question in the chat about what I thought about him doing that. So I guess that's pretty much a summary of anything, unless someone in the chat remembers something else that we need to do to get the entire chat up to date. So, Blue River, I'm going to pat myself on the back symbolically that I could recognize from the letters that it was not Arabic. It was Japanese, even though the letters to me were Greek to me. That's the old expression. I didn't write. The letters are different from the English Romantic lettering that we see. But I could tell that it was different, and I got that far anyway. So we've had a message retracted, Eric Lieber. I guess you didn't like what you said. Is that what message retracts mean? I hope it doesn't mean you said something that got one of the mods to move something. Here's another one. Mimam Hai. Mimam Hai? Is that Hawaiian? Mimam Hai? It sounds almost like, Bali Hai. From one of the musicals. What is that? That's South Pacific, I think. I think it's South Pacific. The music from South Pacific, which probably wasn't Hawaii. I take Hawaii back, but it was, on the Pacific Ocean somewhere. My geography is really bad too. My geography would be bad whether it's 5 to 9 in the morning or 5 to 9 at night. I have no geography, or very little anyway. Melbourne, Australia. Caroline Walsh. What time in the morning is it in Melbourne? That's got to be, you're a lot of hours different. Let us know how early it is for you, or late it is for you, or what time it is for you. I would, then I can either feel bad that it's later in the day for you, or really feel sympathetic. Okay. Let's see, there was someone who, Shelley Malone is suggesting that I also, court is canceled. What happened? There's nothing worse than getting up at 8:30 in the morning than to find out that you did it for naught. We're canceled today. Wow. A juror is sick. Well, I wonder if the juror will be feeling better tomorrow. Okay, people in the chat, if there's some questions, I'll take them. Otherwise, I'm going to be on at 4 with the person his name is Chris, and it's a long Italian name, and I don't want to try to mispronounce it. I want the letters in front of me before I do. But anyway, he was the prosecutor in Monmouth County in 2018 when the arsons and the murders occurred. And he's going to help us understand what was going on at the beginning and give some better context than at least I have, because he was there at the start. He will not be able to talk about anything that was confidential within the prosecutor's office, but he will be able to explain some of the issues or some of the information that's in the public record. He's got a really interesting career. He's a captain in the Navy. He was in Afghanistan doing court-martial proceedings there, and is an advisor to the Navy SEALs and Special Forces. There it is, Gramachoni. Now, I don't know if he's pronouncing it correctly. That CCI should be a ch, but a lot of people pronounce it incorrectly as a Shoni or a Coney. I don't think he'd do Coney, but we'll see how he pronounces his name. Anyway, he's got a really remarkable background. He 10 years in the U.S. Attorney's Office and the head prosecutor on of Monmouth County. Among other things, he's now in private practice. It's just a remarkable career. And so he's going to be talking tonight about the, as I say, the beginning of the trial. Not the beginning of the trial, but the bringing of charges and what was happening at the beginning. Okay, Maureen Conroy is going to set her alarm so she doesn't miss me live. Are you going to bed again? Any news on Pat Galvani? I posted yesterday that the arraignment was held. He's got his lawyer now, and the lawyer is someone who has experience in recalled memory. And I really think that means that they intend to go after Allison Galvani, because, of course, she was 5 at the time, as to whether she could possibly remember what happened. And she's got vivid memories of it. But in any event, I think they're going to go after her, going to go after her on that. And then there's a bail hearing coming up, and I don't have the date in front of me, but I posted it. So if you go on Prof Joe Explains, you'll see the post. It's update 2, and I posted it yesterday. So yeah, that's the update there. Okay, it looks like everybody is saying goodbye. I don't see any more questions. Well, okay, I'll see those of you who can at 4, and otherwise we'll see whether we, there's going to be depending on what's wrong with this juror. If they cancel today because he or she is ill, they may cancel tomorrow. We'll see. If this juror is really ill, what they would have to do is substitute an alternate juror, and they will have an argument about it, because tomorrow is Saturday. Well, what do you know? So he has the weekend to get better. Okay, I see. I can't at 9 o'clock in the morning. I don't even know what day of the week I'm in. So they weren't going to have trial tomorrow anyway. This juror will have 3 days to get better. But let me say what I was going to say. If a juror really gets ill, they'll wait out a day. And of course, they have the weekend now, but they can't wait out forever. They'll have to substitute. And the judge will want the agreement of both sides. The defense may disagree and say the defense wants the jurors that were seated. And that would be an appealable issue if the judge does something else. It would not be a winnable appealable issue if the juror is really sick and it's going to be several days where the juror cannot sit because the judge has to administer the trial, and it has to be administered in a fair but also efficient way. And he can't sit with 11 plus the alternates waiting for the one juror to get better. But that's where we would be. They would move in an alternate juror. Okay. Sandra Baker says she thinks the defense lawyer is patronizing, but good for the witnesses. They seem to understand it. I don't know exactly what you mean by that, but I'm going to read that as the witnesses have been very good at responding to what she does. And I think in virtually every case, if you want to consider it a battle, they have won the battle. And so I don't think she's helped herself. And for the person who hasn't been there and asked the question, the other thing is She does on cross something that no lawyer should do on cross. She wants the witness to answer the question in the words that she wants the question answered. And the effect of that is that the witnesses have not been willing to answer it her way. They want to stick to their guns. I think all but one. They've been remarkable, sticking to their guns and not letting her push them. And she pushes and pushes. That's why she's been called for being repetitive. That's why she's been called for continuing to ask a question after the judge has sustained an objection. Both those things happen because she still wants the witness to say what she wants them to say in the particular words she wants them to say it. And the effect of it all is she gives them the opportunity to answer in a way that helps the prosecution. Because when they answer, they give more context, they give more information, and invariably, it is information and context that helps the state. She also, I guess I'll end with the other amusing thing. The fire chief who did investigations, and I don't remember the title, had prepped for his testimony because although he's been doing investigations for many, many years, first in one county and then in this county, he's never testified in court. And he wanted to prepare for his testimony. So he went on, I think it was ChatGPT, and asked ChatGPT to provide some questions that the defense might ask him when he's on the stand. And then he prepped by looking to those questions and seeing how we could answer them. And that document ended up being handed to the prosecutor by mistake. And then in discovery, the prosecutor gave it to the defense, and the defense lawyer thought she had mined gold there because she was asking him about assumptions he was making and things he was saying. And he kept saying that was AI that did it. It's not me. And it was just really amusing because she was so fond of that document and she really thought she was going to be able to make points. When she found out it was an AI document, she couldn't pivot. She still wanted to embrace it. And the judge, I think, interrupted at least twice, maybe 3 times to tell her it's not his testimony. So that's the other thing that happened. Okay, I do not see any more questions here. Let me just make sure, because if there's a question, I would like to answer it before we go off. Okay. Oh, Jersey Tomato says we better look to see whether Monday is a holiday. Here we go. Yeah, it might be. Oh, well, I may not see you again to do trial until Tuesday. We'll post when we find out if there's a holiday on Monday. Oh, here's a question. So thank you, Jersey Tomato. I'm glad somebody's watching the calendar. Okay, Ollie wants to know, how does the judge get the defense attorney to stop doing what she's doing without showing his anger? Oh, you do it by continuing to do it and not letting your tone or your facial expressions show. I mean, there are a lot of professions where you do that. In fact, I think most of them. Merchants, a customer comes in who annoys you and is asking questions and saying things. A waiter at a restaurant. You're all trained not to let your reaction show. So it's not different for a judge. He just should be even better able to do it. Okay, Taterbug says Monday's a holiday. It's Martin Luther King. So this juror is going to have a lot of time to get better because it looks like we won't be back until Tuesday. Well, I'm going to miss all of you. I was just getting into the swing of doing this, and now we have this long hiatus. Okay. I will tell you that, as I said, tonight at 4, I'm going to have the former prosecutor on. Sunday, Judy Singh from AA Legal Focus and I are going to do something together, and it's about a person who used to be with Howard Stern on the radio, and he was called Stuttering John. And I think he was also an MC for one of the late night shows. I don't remember which one. So I think he's pretty famous. I had never heard of him, but he's pretty famous. and there's a YouTuber that he thinks is maligning his character and belittling him and ridiculing him, and he has sued, and there's an ongoing, battle right now, and that litigation is still in the courts. And so we're going to talk about the First Amendment issues there and what exactly is going on. I think it'll be very interesting for people who know Stuttering John, and it might be interesting to everybody else. I think I will be interested because I didn't know much about it until Judy asked if I would look into it and then go on with her. But that's Sunday at, I believe, 7:30. And then Monday, I don't know that we'll do anything, but we will post if we decide to. Uh, and the rest of that question was, how do you get the lawyer to stop? Well, I will tell you that so far the judge has been unsuccessful. He has tried, but I called her indefatigable, and I'm going to call her indefatigable again. She is really indefatigable. But the problem is that even without the judge doing what the judge has been doing, it's not playing well with the jury. And I'm confident that that's true because of the reaction that the chat is having to it. Chat is having the same reaction that the jurors are having to it. So, okay. I guess we are going to sign off until it looks like Tuesday, unless you come on to the live tonight or the live with Judy on Sunday. It's been a pleasure. The only nice thing about being up at 8:30 in the morning, and actually I was up before 8:30, as you obviously to be here at 8:30, has been having this little interaction with you. But I would like to say that this interaction with you was worth getting up at 8:30, but I can't. I don't want to I just can't lie to you. That's not true. There's nothing that's worth it to me to get up at 8:30 in the morning, because I say to myself, it might be a wonderful thing that's happening at 8:30, but they could have scheduled it at 11:30. It would be more wonderful at 11:30. So, so, uh, but if I had to get up at 8:30, which I had to do, at least I had the chance to interact, although not, only on paper. My meet and greets with members, we actually get to talk to each other, and that's great. Okay. Uh, I'm told to exit from this screen, and I'm going to do that right now. What am I being told to do? Exit full screen. Okay, let me exit full screen. I did that. Okay. You have no idea how complicated for me this is, but I'm getting better. All right, I will see you for the trial stuff on Tuesday. And I hope you have a great day. I hope you have a great weekend. I hope you do something really interesting, or at least you don't do something excessively boring. This is Prof. Joe at Prof. Joe Explains. Hit like if you happen to like this 45 minutes of I don't know what you'd call it, blather. If you're not subscribed, I really wish you would. It helps the algorithm. And I don't know that you'd want to hit hype. Is it hype or boost or something you can do? You only get 3 of them a week. I don't know whether you'd want to waste one on this, but I guess this 45 minutes is different than anything you'll find on any other channel today. So, ciao a tutti.